Alrighty, so this is just We the People News. Okay, I'm not an attorney, not giving legal advice. No ifs, ands, or buts. Okay, I just don't look straightforward. I always look around me to be able to protect myself by any means necessary, and I usually try to do as much as I can on research. Right? Um, again, to protect myself. Now, we talked about affidavits and all that kind of stuff in the past. However, I came across this video. Now, this is a credit consumer affidavit here, but in all actuality, all affidavits has got to be rebutted. If not, then you are in silence of acquiescence. You tacitly agreed to these terms. Okay, so this is by actually an attorney and not really hearsay by me. Okay, it's hearsay by the attorney. All right, so I just wanted to kind of point this out about breaking apart the affidavit that we all must do. Or, again, like I said a second ago, you stay in silent acquiescence and you tacitly agreed to the affidavit. This is what puts government officials really in a default. They just act like they're this great almighty kings and queens up there, and they don't have to never rebut nothing because they got all these magical powers that the fairy dust brought upon them. Okay, and yeah, a lot of judges, you have to go through the process to even find the right judge because a lot of these judges got little fairy dust on them. All right, so anyway, this is about 23 minutes long, but I'm probably going to split this in half because I'm speaking. All right, let's go ahead and proceed forward so we can actually have um, alleged bar member to give us some insight. Okay. Uh, Again, this is a video, so I'm going by hearsay. I've never seen his bar card or got any factual evidence that he is, in fact, a bar member or attorney. Okay. Uh, Alabama Consumer Protection man doing this. Okay. But again, beyond everything else, this applies to every affidavit, even yours. You know, um, make sure everything is truthful to your knowledge of your firsthand knowledge, right? So when they try to go in there and rebut, then you have to come back and rebut their rebut. All right, you guys going to exchange butts. All right, let's go.
My name is John Watts. I'm a consumer protection lawyer.
Oh, by the way, if you see this, Mr. Attorney out there, thank you for your learning process and insight. Okay? All right, let's go. Uh-oh. There you go. There's some more information. All right. I gotta make sure I'm pushing the right buttons here. Oh my goodness.
You ever bought Reese's while eating Reese's? That is some boss behavior.
I'm not.
Compilation of information provided.
I start all over again. You know, if I was perfect, I would be perfect.
Pepperidge Farm thin and crispy cookies. Go on, have a little taste.
You cannot make this up, people.
Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer in Alabama. And I received something today that I thought you guys might have some interest in. And you can see up here in the upper right hand, this was filed today, actually this morning, December 28th. And I've redacted the information that would relate to my client. And this is an affidavit from LVNV Funding, LLC. And they have sued my client. And so now this person that's offering this affidavit is saying, here's some evidence or some information I want to communicate to the court. And I thought it might be good just to go through here and let's take a look at it and see, does this look legitimate? Is this very suspect? What's the deal here? So let's start off. First of all, I'm an authorized representative for the current owner, LVNV Funding LLC. Well, that sort of assumes that they are the current owner. We just had a video, I think it was yesterday, on the difference between owing a debt and then a debt buyer like LVNV owning a debt. So this is assuming that they own the debt. Now, we don't make that assumption, but they certainly do. And notice it says I'm an authorized representative for LVNV. Here's what it doesn't say. I work for LVNV. I'm an employee for LVNV. I've been working for LVNV for 12 years. It doesn't say that. Now, part of the reason is LVNV has no employees. And so this person is going to work for most likely a company called Resurgent. But they don't want to say that because then that kind of raises some questions in the judge's mind about, well, wait a minute, you don't even work for this company. And then, of course, they don't have a witness at trial. At least they never have in our cases. And so then the lawyer's saying, well, Judge, Resurgent and LVNV, they're almost the same thing. But now, of course, when we sue them, they go, oh, totally different companies, totally separate. Don't ever lump them together. So that's just the first part here. All right, well, let's look now at paragraph 1. I have personal knowledge regarding plaintiff, that would be LVNV, plaintiff's creation and maintenance of its normal business records, which includes the computer records of its accounts and corresponding receivables. This information is regularly and contemporaneously maintained during the course of plaintiff's business. Okay, that's just kind of regurgitating what the law would typically say for under hearsay for a business record exception. Okay, so there's nothing particularly interesting there except to point out that this person, again, gives us no indication as to why they have this personal knowledge. How do they have it? What's their experience? When did they get it? We have no idea because the affidavit doesn't tell us. And if we look down here, we see this is a Felicia Richardson.
Not attorney, not giving legal advice, but there's always what? Ask questions to yourself even. But you can always ask questions to someone else. But slowly read these things so you can break it apart. Okay? And ask questions. How does this apply to me? Always. Or if you write yours deal, really just go in there and be precise as your facts that came about. Okay? Do not lie. Police can lie all they want. You just can't do it. Okay, people?
Signed this back in August, and this looks like South Carolina. And so it was filed 4 months later in this case. All right, so let's look here at paragraph number 2. This is where it starts to get interesting. In the regular course of business, plaintiff acquires revolving credit accounts, installment accounts, service accounts, and or other lines, credit lines or obligations. Notice this next sentence right here. I don't know if my little cursor will come up, but it's this very next one here. The records provided to plaintiff in connection with such acquisitions are represented to include accurate information provided by the original creditor and or subsequent owners, and that information is incorporated into plaintiff's business records. Such information includes debtor's name, social security number, account balance, identity, original creditor, account number. Well, let's go back. So it says, hey, the records that are provided to LVNV are represented to include accurate information. Well, that's amazing, because a lot of the purchase agreements specifically say there is no representation that these records are accurate. But here we have this person in an affidavit swearing under oath that, hey, when we get these records, there is a representation that this is accurate information. And this is provided by the original creditor and or subsequent owners. Well, now, of course, if it's a subsequent owner who's saying it, but the original creditor didn't, well, then the subsequent owner has no basis. I mean, I think I used an example the other day of if I sell you the Golden Gate Bridge, you're like, hey, I bought it.
Yep. Can't make this up, right?
That gives you energy. I've been all over the world as a wildlife filmmaker. The best.
The Golden Gate Bridge, you're like, hey, I bought it. And, John Watts said it was a legit deal. Well, if I don't own the Golden Gate Bridge, and I don't, then I have no right to sell that to you. Well, if the original creditor says, hey, here's some accounts, but we make no promise, no representation, and then the first debt buyer sells it to a second debt buyer and says, we swear to you these are accurate. Well, it doesn't matter because they don't know if it's accurate. Only the original creditor would know if it's accurate. So this is one reason why we need the purchase agreement. And if there's more than one debt buyer, we need every single purchase agreement going all the way back to the original creditor. Does that make sense? I mean, we've got to see what did that original creditor say? Because if the original creditor says, we don't make any promise, any representation, any of this information is accurate, well, then how could any subsequent debt buyer who sells it to the next debt buyer say that these are accurate? And this is part of why they don't want the purchase agreement to come in, because they just want to say this stuff in affidavits, even when it's not true. Now, is it true here or not true? I don't know. I haven't seen the purchase agreement. I suspect I won't see the purchase agreement. But, if this goes to trial, you can imagine that we're going to be, definitely bringing that up with the judge. Judge, look, they're making this statement about what the purchase agreement says. And we have a concept in the law called the best evidence rule. And the best evidence rule traditionally said you have to put in the original document. A copy is not sufficient. Now, that's a little bit of sort of a, from the time period of people like, handwriting copies. Well, maybe they made a mistake, okay? Now we have photocopy. Of course, now we can change stuff in PDF, But where this really comes up is not so much in is this an original or a copy, but it's when people want to testify about the contract. Let me tell you the terms of the contract. Well, no, the best evidence is not you yapping in the witness stand. The best evidence is, let me look at the actual contract. So see, if we're arguing about, was this person married, was Bob married to Sue? Okay. And you might say, well, how why would that come up? Well, it comes up in wrongful death cases. Okay. So Bob has been killed in a wrongful death, and now Sue comes up. Nobody's ever met her. She says, oh, by the way, I was married to Bob. He's my husband. And so now I have the right to bring the wrongful death lawsuit. Well, you can imagine we're in front of a judge and she's saying, oh, yeah, we were married. And the judge says, well, let's stop showing me pictures and Christmas cards. Show me the marriage certificate. Well, I don't want to do that. I just want to talk about, well, no, see, the best evidence would be the marriage certificate. It would be even tax returns showing that you're filing, married, joint filing or whatever. So here, the best evidence is not, who is this, Felicia Richardson, talking about what the purchase agreement says. It's just, let's look at the actual purchase agreement. Then we don't have to rely on what somebody is interpreting it. And by the way, if she is testifying live, we would ask her the question, so tell me how many times you have read the purchase agreement that relates to my client's account. Well, I don't remember. Well, have you ever read the purchase agreement? I don't think so. Have you ever read any purchase agreement? No, they won't let me. That's how this thing plays out. So this paragraph number 2, sort of crazy here. Okay, so best evidence rule, the purchase agreement, and they got big problems with this. Now, let's look.
Okay, we're going to pause right there because we're going to make it a 2-part. Peace away, the people news.